And we're off to the races. Less than 2 minutes in and we've already got the classic sovereign citizen playbook. Challenge the court's legitimacy, question jurisdiction, and demand constitutional verification. The problem? Courts don't usually stop everything to debate legal theories pulled from internet forums.
You're entitled to 10 minutes of oral argument. If you wouldn't mind putting your name on the record, please.
I'm the executor and sole beneficiary of the trust and estate of Mr. Kevin Dwayne Craft, the legal persona. I'm not here making a general appearance. I'm here by special divine appearance, judge, to settle a matter, to call for a constitutional court of record to ask for a summary judgment upon the truth and facts that I placed upon the record with my documents. I stand firmly on my rights, and I'm here to ask for the summary judgment, please.
You asked for.
I do also have a few questions.
I understand you're pro se, and then therefore you get a little bit of leeway, but typically the judges don't answer questions. We're the ones who ask questions. This isn't like a trial court where it's a very kind of back and forth. The Court of Appeals is more structured in terms of the lawyers or parties come up, they make their arguments. The judges may or may not have questions for the person, and then it's submitted, and then we go back and discuss the matter, and then at some point in the future we come out with an opinion. So it is different in that respect than trial court.
Understood. But I am wondering if this is a court of constitution, and would the Constitution be applied in these proceedings?
The Court of Appeals, the Michigan Court of Appeals, is provided for under the state Constitution of 1963.
Is that a yes?
That's the answer I'm giving you.
Okay. I'm asking to verify to make sure these proceedings are legitimate. The Constitution has two jurisdictions: common law, admiralty law, or maritime tribunal. And I'm asking in which context would this court try to enforce jurisdiction on me?
We're acting under the state Constitution of Michigan of 1963.
Moving forward, I'm here to pretty much address the court's error for ignoring my motions. Notice of dismissal, default judgment under Federal Rule 55 was filed December 12, 2022. Under Federal Rule 55, if a party fails to respond to the defendants themselves, and this is confirmed by my affidavits, and other means, the clerk must officially record a default judgment of that party. I filed several motions and they were ignored. That's why I'm here. In Haynes versus Kennar, 404 U.S. 519, 1972, courts must be understanding and not easily reject motions from people who just represent themselves. And that's what took place in this matter. In Article 1, Section 17 of the Michigan Constitution prevents courts from ignoring motions and guarantees that people have a fair chance to represent themselves in any argument and evidence. That did not happen. That's why we're here. The state ordered me to take a paternity test. In Monell versus Department of Social Services, which is a New York State case, the Supreme Court case established that municipalities' liability under the Section 1983 for constitutional violations in the context of child support cases, where the appellant argues that a warrant should be required for me obtaining genetic and biological material. I think it's very sensitive when a state injects an order asking me to give genetic and biological material without a warrant. That's really sensitive material. It's not like a document or anything. That's personal biological material. That's why those specimens were not granted. That's why I deny any consent or any contract with the state or Title 40 agency to give away my biological and genetic material. That the case Monell is relevant because it underscores the importance to ensure that government agencies like the friend of the court on this context These are for-profit agencies disguised as government agencies like the Friend of the Court, adhere to constitutional standards where collecting evidence potentially implying the need of procedure safeguards to protect individuals' Fourth Amendment. That's why I asked, what is the constitutional court? The action.
Now, here's where things get interesting. He's trying to frame a court-ordered paternity test as an unconstitutional search and seizure. It sounds compelling on the surface, but family courts have long recognized genetic testing as a legitimate tool for determining parentage. That's a much steeper hill to climb than he seems to realize.
For genetic material is protected by my Fourth Amendment right. The Fourth Amendment protects individuals from unreasonable searches and seizures and safeguards one's privacy and assurance that any such search is conducted within the boundaries of legal requirements. I see that they're not here today, and that's some questions that are raised, and those were my concerns. On August 11, 2022, the Kent County ordered an appointment for me for genetic and biological testing. In a testing laboratory, DNA Diagnosis Center is a business, and I can prove it's a business because I have their Dun and Bradstreet numbers, 877-184226 for the record. They also said, when I thought this was funny, the state of Michigan stated that it would pay the cost of the genetic test, and if I wasn't excluded, that I would be responsible for that cost. And with that being said, that set alarms. The state of Michigan is also a business, and with them fronting the cost for me, that presented an alarm for me because I don't choose the contract with the state of Michigan. I don't choose to do business with them in this regard with another business. It seems like a coercion of some sort for them to upfront the cost if I was going to be responsible. I do not consent to that business arrangement. The state, they failed to show a promissory note of a contract of any sort. I submitted documents, notice to the court to demand dismissal for lack of jurisdiction, demanded to see an open court evidence of personal and subject matter jurisdiction, and notice of court to refusing to appear voluntary. And I do not accept the offer to contract, and I do not consent to these proceedings. That affidavit or notice to motion was submitted on November 28th, 2022. So again, I'm just bringing up the point that I submitted numerous of documents asking for clear evidence or asking for due process, also asking for just quite frankly, to be transparent with what's happening. And I believe I deserve the right to see in writing what gives them the authority and what contract am I entering. I want full disclosure. In Burns 322 BR 719, a creditor must provide proper documentation such as a promissory note, contract to substantiate a debt or court claim. They did not. More documents I filed. Affidavit inserting corporate nature of government entities. I submitted that document because I'm concerned that these are for-profit businesses disguised as government agencies. I have proof. Kent County Court, Dun and Bradstreet number for the record, 152906082. Kent County Friend of the Court, Dun and Bradstreet number, 6088333133. State of Michigan, Dun and Bradstreet number, 504698428. These are businesses. I would like to state for the record that I am not a corporation. I'm a living, breathing person, human being. With these being businesses, they have to abide by the same rules as other businesses. And may I give an example? For example, McDonald's. McDonald's can't force me to eat their Big Macs. They need my consent. None of these businesses that I've mentioned have my consent to do business with them. Section 458 of the Social Security Act, incentive payments to state It's a conflict of interest. And it's my argument right here, right now, that the state incentivizes them for it incentivizes them to collect more child support. The main argument I have here, and for you guys, is full disclosure. You know, it seems like they enter me in a contract without my consent, without full disclosure, and that's the problem here. You know, I'm here to argue subject matter and lack of jurisdiction. No evidence was established in my involvement of a common law crime or damages, and I did not commit any common law crime. Notice of court to refusing to appear voluntary, and I do not accept these contracts, and I do not consent to these proceedings was another motion or notice to motion that I submitted 11/28/22, and it's basically its evidence is not, they didn't provide any evidence of an injury or injured party, and
Mr. Kraft, you're out of time. We understand that you raise issues of disclosure,
yes,
jurisdiction, remedy, and as I indicated, your brief, as with all the appellants and appellees we have here today, the briefs that you submit are kind of the key issue or the key tool that we use to resolve cases. And so I just want you to know, we have your brief. We're going to go back. We've had research attorneys look at it. We're going to look at it again. We're going to discuss your case. And then you'll get an opinion from us sometime within the next few weeks.
If I may, one last thing.
You've got, if you can do it in 20 seconds.
I can. The government must prove charges beyond a reasonable doubt with clear evidence, especially when making the claims against someone. And I'm asking you guys right here, right now, they did not provide any evidence against me. And I would ask you to dismiss this without prejudice.
Ah yes, the famous government is secretly a corporation argument. This theory pops up constantly in sovereign citizen circles. But having a business registration number doesn't magically transform a government agency into McDonald's. If it did, every city hall in America would be selling Happy Meals.
Yeah, y'all tweaking. I understand that our system's broken, and I'm just a little cog chilling. Hi, I'm Cog. Nice to meet y'all. I mean, no speak English on that one, but everything else, yes. I don't really know what's going on with my support system, but it's
This is my turn to talk, Mr. Mullins.
you guys know I have no clue what the hell y'all are doing. You have no details. You're making a bunch of judgments on very, 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 very misguided details, and the frail line understanding that you understand.
You're going to talk with your attorney.
What's the Rotary Club? Who am I? Do you guys know who I am? My name's Jacob Edwin Mullins. You guys know who I am. That's crazy. You guys are playing silly ass games.
Did you Jacob Edwin Mullins?
Yes.
All right, thank you. And Mr. Feigelson, if you would enter your appearance, please.
Yes, Your Honor. Good afternoon, Assistant Public Defender Stephen Feigelson on behalf of Mr. Mullins, who's present by way of video conferencing this afternoon.
All right, thank you. Mr. Mullins, this is a felony complaint indicating on or about January 24th of 2025 at 216 East Thomas Street, Lansing, Ingham County, Michigan. Sir, count one alleges that you did willfully and maliciously burn, damage, or destroy by fire or explosive personal property with a value of $1,000 or more, but less than $20,000. That is contrary to law. It is a felony, carries a maximum penalty of 5 years and or $10,000 or 3 times the value of the property damaged or destroyed, whichever is greater. Do you understand the charge and the maximum penalty, Mr. Mullins?
I understand your perspective of what occurred and outside
Well,
of that.
hang on. Before you go too far, this is just what's written on the paper. You are presumed innocent. Let me finish, okay? And you'll understand why I'm saying this. You are presumed innocent. So we want to make sure that you don't say anything today that can be used against you. So when you get to talk with your attorney in private, that's when you're going to want to talk about what happened or didn't happen. I can only tell you what the charge is and the penalty is, and then you'll talk to your attorney and they will help you prepare a defense against the charge. Does that make sense?
I'm 29 years old. I understand. Like, you know what I mean? I get it. For real.
Good, good,
Like,
good.
I'm not-
Okay. All right, then, Mr. Mullins, you understand the charge and the maximum penalty. You don't have to agree to it. You just understand. Is that right?
Yeah, no
Okay.
disrespect. Just
Okay. Perfect. All right, now you do have rights as well. You have the right to plead guilty, not guilty, or stand mute. You have the right to a trial by a judge or a jury, and at that trial you can present or confront witnesses. If they would not appear, the court can order them to do so. You also have the right to a lawyer, and if you cannot afford one, one can be appointed for you at court expense. Additionally, you are presumed innocent, as I said earlier, and if you are found guilty, it has to be beyond a reasonable doubt. You also have the right to remain silent. Anything you say or write can be used against you, and you always have the right to have a lawyer present with you at any time that you are questioned. Do you understand those rights, Mr. Mullins?
Was it, you said read anything you say or write can be used against you? Did you say that?
Yes, I did say that. Yes, sir.
Me no speak English on that one, but everything.
Okay, good. All right, then, is he applying for an attorney today, Mr. Feigelson?
Yes, he is. He presently works with our office on another matter, Your Honor.
Okay, thank you. So, Mr. Mullins, what we're going to do is we have 2 hearings set for you on this. A probable cause conference, which is the first hearing. That is February 6th. That's at 8:30 a.m. with Judge Simmons. Excuse me. You are allowed to appear remotely on that, so that's why you will have a colored sheet. I think it's kind of a bluish green. Yep. Okay, you should have that, so you can appear February 6th at 8:30 a.m. remotely or in person. The second hearing is a preliminary exam. You have to appear in person for that. That's on the 6th floor of City Hall, Courtroom 4, and that's February 13th at 8:30 a.m., also with Judge Simmons. So you've got the notice and the Zoom instructions, correct?
Yes.
Good, good. Okay. Now, is there anything I've told you so far that you do not understand?
The one thing I didn't speak English on, yeah, but other than that, yes, everything else I did. I'm an artist.
Okay.
I'm writing a lot of things, so when I write stuff, it's like almost like, you know what I mean? So that's just a arbitration contract thing that I didn't like. So I mean, we'll settle through that. So I would like to just voice that. Other
We
than
could
that, no
just
disrespect.
move
Yes.
forward, sir. Appreciate the.
Correct.
Yeah. You'll talk
Thank you.
about that with your attorney, absolutely. Okay, so, Mr. Mullins, I'm going to stop the live stream so that I can protect.
A low PR bond or low cash and surety bond, Your Honor. Thank you.
If it's
All
any
right,
money,
thank you.
I can't afford it. Let's just say that. I ain't got nothing. Y'all ain't give me any tools to get a job since I've been released from your guys' care. Now, I don't really know what's going on with my
Okay,
sports.
this
but
is-
it's
This is my turn to talk, Mr. Mullins. Okay, you don't want to talk about that, because like I said, you're gonna, you might say something that can be used against you. So, the court's gonna look at 2 things, Mr. Mullins. I'm gonna look at whether or not you're a flight risk and whether or not you are a danger to the public. In regards to that, I'm gonna look at your criminal history. I'm gonna look at the allegations. I'm going to look at your ties to the community, your employment status. You live with your parents. I look at all of those to determine 2 things. I do have a concern for the safety of the public. On the matter that I arraigned you on first, the arson, you are presumed innocent, but as I look at the allegations, it presents a concern to the court for the safety of you and any other individuals that reside in that location. I understand that would be your parents.
1995.
Okay,
Trust me.
this
It's all right.
is my turn, sir. Okay,
I
so
bought it,
based
too.
on that, I'm not going to grant you a PR bond because I don't find that that is sufficient to ensure well as protect the public, as specifically here your parents. The court is going to set a cash surety bond on this of $10,000
What the
to
fuck?
ensure your appearance. We're not done yet, sir. Okay, now, first of all, the condition of your release is do not miss any court dates and do not violate any state or local laws while you're on bond. You're not to possess, purchase, or consume any alcohol or controlled substances without a prescription, and you're not to leave the state of Michigan without permission from the court. You also are not allowed to possess or purchase any firearms, ammunition, or dangerous weapons, and you will have to report to pretrial services so that they can set up any pretrial supervision that may be necessary. That's either a phone or an in-person interview. Now, I'm also going to tell you, you cannot have any contact with Daniel Mullins and or Barbara Mullins. You cannot call, write, page, email, text, no electronic communications of any kind. You can't have anybody else contact them on your behalf, and no threatening, harassing, or molesting behavior towards them or anyone else. Additionally, you cannot go within 2,000 feet of where where they're located at any time, including work, home, or school. Not go there, and you can't have any contact at all. Also, you're unable to give me an address at this point. So if you are released, you have 24 hours to notify the public defender's office of the address where you're staying. If you don't do that within the 24 hours, the court then sets a bench warrant for you. Do you understand that? Do you understand what I'm telling you, Mr. Mullins?
I understand that our system's broken and I'm just a little cog chilling. Hi, I'm Cog. Nice to meet y'all.
Okay, all right. Let's go over the other file then. This is, again, the 24-03520. Judge Simmons has ordered that you be remanded on that case file because you failed to appear for the probable cause conference. So you will not be released before that hearing that is to be set. Do you understand?
Yeah, y'all tweaking.
All right.
You guys know I have no clue what the hell y'all are doing. You have no details. You're making a bunch of judgments on very, 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 very misguided details. And the frail line understanding that you understand.
You're going to talk with your attorney.
What's the Rotary Club? Who am I? Do you guys know who I am? My name's Jacob Evan Mullins. You guys know who I am. That's crazy. You guys are playing silly ass games.
Did you have anything else?
I do not, Your Honor. Thank you.
Thank you.
And I am going to order a CMH evaluation on that new file as well. All right.
That's about the one good thing you've done today, and it's not your fault. You're an amazing person, I'm sure, and I'm not trying to hurt your feelings or like I'm a frustrated individual. So let me just say, like, I'm sorry for the disrespect. I know it's not your fault necessarily.
And this is the moment the hearing completely leaves planet Earth. The judge asks a simple yes or no question, and somehow we end up with "Hi, I'm Cog." If you're wondering why the court ordered a competency evaluation a few minutes later, well, that decision is starting to make a lot more sense.